Hello, welcome to another wiki procedure, and today we're going to look on how you can obtain a divorce decree in Kenya. We have included an external link which is going to direct you to our wiki procedure website page, where we have explained in detail how you can go about the application process to obtain your divorce decree. We have also included external links to websites where they have given more detail on how you can file for your divorce petition. And we also included laws on divorce and settlements. On your right hand side of the screen, we have the select language option, which allows you to select a language which you are more familiar with, and which it will be easier for you to comprehend the procedure in our wiki procedure page. And by choosing the language, what this will do is that it will translate the wiki procedure page to the language, your preferred language, and it will make your experience much easier. But for our purposes today, we are going to use English for the explanation. So let's get back to our presentation, and the list of items we're going to cover in this session is the need for the divorce decree, the eligibility, the required document, steps to follow, fees, validity period, processing time, office locations, and other relevant information. And this presentation today is brought to you by wikiprocedure.com. The need for a divorce decree. A divorce is a legal ending of any marriage. Of any legal marriage. A divorce decree is that final order given by a court to complete divorce proceedings, and it's usually signed by a judge. Like in any other country, in Kenya, a divorce decree is obtained from the court. A divorce decree is needed when applying for a name change. That's one of the uses. The divorce decree is needed when applying for a passport, visa, or work permit. A divorce decree finalizes the divorce proceedings. It saves a person. It saves a person any cruel or violent treatment that has been in a marriage. It also makes the divorce official, even after a period of separation, and it is proof that the two are no longer married. And finally, a person can remarry legally once the divorce decree is obtained. The eligibility is that any legal married persons can apply for a divorce and must have reasonable grounds for applying for the divorce. In Kenya, to end your marriage, you must have been separated for at least 12 months before you can formally apply for a divorce. The court does not consider whose fault it was that ended your relationship. You also need to note that in order for dissolution of marriage, will not be made if the court is satisfied that there is a reasonable likelihood of cohabitation being resumed. So the court will only dissolve the marriage if there is no likelihood that you can resume your cohabitation. And an order of dissolution of marriage must be based on the grounds that the marriage has been broken down irretrievably. So the required documents are the certified copies of the parties' valid passports or national ID, proof of marriage, that's the marriage certificate, proof of evidence of existence of stated grounds of divorce, for instance, police reports, doctor's reports, or any other proof. For instance, in cases of cruelty or violence, the applicant must present evidence like a police report if at any time the partner was violent, and a police report, and the case was reported to a police. You can bring a doctor's report as proof of evidence in case where the partner was violated and went for medical examinations, or a witness can also come forward and present at any one time, can witness that the person was violated by the partner. So the witness can come and can be brought to support the case in court. And in case of even insanity, a doctor's report may also be required. Okay, so and also you need the file petition. So let's move on. The first steps, or the steps to follow, the first step is to file for the divorce petition, and the petition is the main document that outlines the grounds under which a party is petitioning the court for divorce. It may be presented after the lapse of at least 1 year since the celebration of the marriage. So thus you have to note that the petition can only be presented after a lapse of at least 1 year since the celebration of the marriage. A party to a marriage may petition the court for separation or dissolution of marriage only on the following grounds: adultery by the respondent, cruelty, or desertion, for at least 3 years. So the divorce petition is filed together with the following documents: verifying affidavit, notice to appear, acknowledgement of service, list of witness statements, and list of procedures. Let's move on. Step 2 is that is applications for directions. A chamber summon application is filed after 15 days of service of the petition. This application costs a minimum of 500 shillings for filing. This application must be accompanied by a commissioned affidavit of service or non-service, and the affidavit costs 75 shillings to file. And the affidavit of service or non-service is the statutory declaration shown by the court processes after stating whether the respondent was served or not, and the efforts made to trace the respondent for service. The third step is listing of the petition for hearing. So the application is thereafter fixed for hearing, whereby the court register confirms whether the petition is defended or undefended. The registrar then directs the petition to be listed for a hearing for 1 day. Now, if the next step is hearing of the petition. The petition is fixed and the hearing takes place for 1 day, depending on the number of witnesses and the court schedule. So let's continue. The fifth step is now issuing of the decree nisi. After a successful divorce petition, a decree nisi is thereafter issued after the judgment. A decree nisi is an court order that states that the marriage has been dissolved by the court after the said court has been satisfied that the petitioner has proved the grounds of divorce and pleaded by the petitioner, and that the petition has not been presented or prosecuted in collusion with the respondent, and a further condition that the petitioner has not condoned the acts of cruelty or adultery etc. as in the petition. So the steps number 6 after being issued with the decree nisi is finally being issued with the decree absolute, and the decree nisi is later made absolute, that is final, within 1 month from the date when it was issued. And this 1 month is the time to raise any appeal or review. So after the decree nisi has been issued, you have 1 month to appeal, and after the month the decree nisi becomes decree absolute. The decree absolute is the last document to finalize the divorce, and is the final stage of the divorce proceedings and confirms the dissolution of the marriage. Remember, that's the final stage. This is the final order prepared by the petitioner for signing by the judge, and after the judge has signed, now the divorce is final. The last step is presenting the order to the marriage registrar. So the last step is you have to present the decree absolute to the registrar of marriages. So you have to present, the final step is presenting a certified copy of the absolute decree order to the marriage registrar, so that your marriage can be stricken off the records, and the decree to be put up in the records, so that it may be recorded that you two have separated. The applicable fees is that you need to pay 500 for chamber summons, Affidavit service is 75 shillings, and in most cases the court directs that each party meets their own cost, but the successful party can claim costs from the other side, especially for transport, legal fees in a contested divorce. The validity is that the divorce certificate is valid immediately after the divorce is granted and registered. The validity of the divorce decree is forever as long as both parties are alive. The divorce decree can lose its validity if the divorce parties decide to get married again. The processing time depends on the issues surrounding the divorce proceeding, and on average, the court process normally takes around 3 years. So the location of the judiciary office, they are at Sharia House, Arambe Avenue at the ground floor, the same building hosting the Registrar of Marriages, and you can also visit them through their website at www.statelaw.go.ke. So the other information is the following can be considered grounds for divorce: adultery, cruelty, neglect for at least 2 years immediately preceding the date of presentation of the petition, so separated for at least 2 years. Desertion, if the spouse has deserted the family. If the spouse has been sentenced has been imprisoned for life or a term of more than 7 years, can also be grounds. And if this grounds for divorce, and even if the spouse is as incurable insanity, the court may deem any of those reasons appropriate. So thank you for watching wikiprocedure.com. I urge you to like our video, hit the like button, even just click on the subscribe button on our YouTube page, and tell a friend to tell a friend about our videos. You can also browse through our Wikiprocedure Kenya page. We have many procedures about different processes, how you can make applications, and how you can obtain different services. So thank you once again, and I wish you all the best in obtaining your divorce decree. Thank you.